My guest today is Judith February, I think very well known as a political commentator, analyst, author. Judith has held a number of senior positions in civil society organizations. I think I first met you back in the days of IDASA. And since then, you've been with Institute for Security Studies, Human Sciences Research Council, and now you, for about a year and a bit now, you've been the executive officer at Freedom Under Law. Let's start, Judith, by just telling our viewers what Freedom Under Law is, why it was founded, and what your major areas of focus are.
Thanks very much, Mike, and it's lovely to chat to you. So Freedom Under Law really our core business. We were registered as a not-for-profit about 15 years ago, and it really was around promoting the rule of law in Southern Africa. Granted, much of our work has been in South Africa of late, given the challenges that we have had with regard to the rule of law. But really, part of it is the promotion of democracy, advancing the rule of law, but seeing the rule of law as foundational to constitutional democracy. And we've mostly pursued our goals through strategic litigation. So on the issues around the conduct of judges, for example, Judges Hlophe and Matata matters, but also with regard to the National Prosecuting Authority. One of our major focuses at present is the Judicial Service Commission and its performance, because, of course, the appointment of judges is crucial to ensuring that there's trust in the judiciary and also, therefore, securing its legitimacy. And that, in turn, is crucial to upholding the rule of law. So we have released a report late last year on the performance of the Judicial Service Commission, and certainly recommendations for improving the way that it works, and that has really been a focus of ours, along with judicial conduct.
We'll come to the Judicial Service Commission in particular, but just in general terms before that, it's been said often and for a very long time that the judiciary has been a bastion in this country, a bastion against state capture and attempts at undermining constitutional governance, and a bastion in favor of the rule of law, civil rights, etc. Would you say that at present that bastion is growing in strength, or is it weakening at the moment?
Mike, I think it's such a tricky question because, of course, there are so many threats to the rule of law in our country, and they are serious threats. And it's also the threats are multi-layered. So they're those which come from politicians, for example, those within the ruling party, but also outside of it, who have attacked the judiciary when perhaps judgments have not gone in their favor. We think about people politicians within the ANC, but then, of course, also the EFF's Julius Malema. And the other layer to that is, of course, the Judicial Service Commission, its role in the appointment of judges, how well or how badly it has fared over the past decade or so. And then, of course, the other layer of that is the profession itself, the legal profession itself, whether it's attorneys or advocates, the Legal Practice Council, the role of the Legal Practice Council in disciplining attorneys or advocates, and with regard to conduct. And we've seen some pretty egregious examples of poor conduct by legal professionals. And so all of this it's multi-layered if we look at the way in which the judiciary is made up of both judges and then, of course, the practitioners who have to practice the law. And there have been failings, but I think that by and large, the judiciary has held the line at important political moments, and we've seen that in the Constitutional Court, even with former Chief Justice Mogoeng, who may not have been the greatest Chief Justice we had, but at a moment where he needed to defend the Constitution in matters with regard to former President Jacob Zuma, that court did. And of course, we saw very powerful judgments later on, also involving former President Zuma, by Justice C.C. Kampempe, for example, on the Concord. So in most of, I would say, by and large, the judiciary has been that bastion that people, despite the Afrobarometer research, which shows declining trust in all institutions, I would say that, and if you look at the Human Science Research Council's research on the way in which the Constitutional Court has protected basic fundamental rights, socioeconomic rights, the courts have by and large held the line. But of course, we have to continue to guard the guardians and to guard the institutions of democracy. And I think it's trite to say, but that requires eternal vigilance, because of course, where the institutions are weak or are captured, that is where democracy dies. And so we have to be careful when we see examples of weakening in appointment processes and so on, that we do speak up about it, that we raise awareness about it, and that the judiciary understands too that we in civil society are going to hold it to account for decisions, but also the Judicial Service Commission in terms of appointments and so on. So it's a mixed bag, but I think by and large, we've been fortunate that we haven't had the capture of the judiciary, as we've seen, for example, in Zimbabwe and such like.
Yeah. I mean, I think it's fair to say, my perspective anyway, is that while, as you say, Mogoeng may not have been the greatest Chief Justice we ever had, and there probably are quite a number of other sitting judges who are not necessarily legal giants. But at the level of independence and integrity, I think we've been very well served with one or two obvious, but only one or two exceptions. The independence of the judiciary, I think, has been very carefully upheld by the members of the judiciary.
I think, yeah, absolutely. I would absolutely agree with that. And you know, you raise the important point about independence, because of course that is the that is core to our understanding also of a judiciary which is credible, is one which is independent. And we've seen a case upon case where the courts have you know, found whether it's against government and so on. And despite, Mike, I think despite the fact that we, you know, there've been great criticisms of the ruling party and the way in which there've been attacks on the judiciary in some cases, but by and large there is a consensus that the courts are to be respected, and also that their judgments are to be implemented. Now that's something quite separate, the capacity of the state to actually do that, and sometimes a kind of begrudging unwillingness, but by and large there's a consensus within society. And I think that just to add to this, I think if you look at what's happening, for example, in the United States with Donald Trump, his trial and so on, you realize how quite sophisticated South Africa is in its understanding of the independence of the judiciary, and that and our willingness to accept the role of the courts as arbiters of fairness and so on. And so I do think sometimes we give ourselves a bad rap in a sense, and we are a young democracy, because if we look at what's happening around the world where democracy is under threat, that in fact in many ways, also in the creation of precedent, we are rather sophisticated in that. But I think again the point is that we need to guard, protect and defend what we have and improve it.
Let's look at the Judicial Service Commission in the JSC. Arguably the beginning of last year, I think it was February last year, when they were holding the round of interviews for the position of Chief Justice, it reached a bit of a low point. You know, we had various attempts by commissioners to intimidate candidates, spreading false rumors about one of them, you know, at the last minute, a real sort of ambush situation. Yeah. Since then, well, we've got Judge Zondo in as Chief Justice, and therefore he chairs most of the JSC sittings. But some of the commissioners have also changed. What's your take on the organization now? Has it improved? Still problem areas with it?
Mike, I think so. You've rightly pointed to previous processes. I mean, characterized by ambitious, sexist comments, commissioners shouting at each other, sort of in many ways an undignified spectacle, and that in and of itself isn't good for the public confidence that people have in the judiciary and institutions. And so, you know, we sort of hit a point where we were at rock bottom, really. But I think recently we have seen, since the beginning of this year, an improvement in the way in which, in the tenor and the manner of questioning. For example, the JSC has also introduced additional criterion guidelines to improve and inform this process of public interviews for the selection of judges. And that is, we think, has contributed to a more encouraging tone. And so there is also a greater interest in people's, in the jurisprudence, in people's, you know, their legal abilities and so on, that it's not simply sort of often ad hominem attacks or personal questions. And there is a sense that the candidates who appeared before the JSC were treated more fairly. They were able to engage more rigorously about core matters relating to their experience and their understanding of the law. And so the criteria, as we've argued, as Freedom Under Law, you know, we thought that good, solid criteria would be seen as a key component to ensuring that the interview process improves. And so I think from the point of view of the tenor of it, the atmosphere around it, and also Judge Zondo is a you know, a very calm, level-headed, respected Chief Justice, and so that has lent us sort of calm to the proceedings. But of course, you know, one needs to match the criteria to the outcome. And so certainly Freedom Under Law in the last session of the JSC hearings, which happened at the beginning of October, we had expressed concern around the Supreme Court of Appeal vacancies, of which only 2 individuals were appointed, and no slight on the individuals, but you know, we did raise the issue of Judge David Unterhalter, who didn't make the cut. And so I think overall, the process went more smoothly. But the question is how you tie the criteria to outcomes. And I think there we're still a bit bumpy, as well as that one has to look at the candidates who are putting themselves forward. And for example, the dearth of candidates for our highest court, the Constitutional Court. And the Chief Justice has appointed a number of academics, I think 3, to act because they just haven't been the applicants. And I think that is something which needs urgent attention. But that is something about the process, and I think a lot of people are really bruised and don't want to put themselves through an unseemly process. So hopefully, perhaps, you know, now that things have sort of calmed, there's a calmer presence there, and better questioning, people will. But I don't think the Unterhalter matter has helped the situation, and so I think that is a blot on the JSC for the present sitting.
It's not the first time by any means that someone who, on objective criteria of, you know, legal qualification, experience, and just being regarded as a particularly brilliant lawyer, has not made the cut. The same thing happened to Jeff Budlander. Same thing happened to Jeremy Gauntlet. Also, both, of course, white men. It's difficult to, you know, draw conclusions from any one such instance, but when they repeat themselves like this, you do have to wonder what's going on. Let's just talk about this new development, though, of the acting justices. For people who might not recall, the first bench of the Constitutional Court, I think, had only 4 people on it who had served as judges in the High Court before then. So quite a number of people were brought in from academia, people like Cato Regan and Albie Sachs. And from practice, including Chaskelson, for example. We've tended to move then to a Constitutional Court bench which has been almost exclusively appointed from the ranks of sitting judges. And now there appears to be a bit of a swing, 3 non-judges being brought in to act. And some writers, I think yourself, Peter Voss as well, I think have pointed out that this can be a very good thing because it can bring much greater depth of constitutional scholarship to that particular court than you might get from someone who has just spent 10 or 15 years as an ordinary High Court judge. Would you agree with that? Do you want to expand on that thinking?
Yeah, I think so. There is a point to be made that, of course, and these are fine lawyers, so who have been fine academics who have been put forward. Alan Dodson is one of them. He didn't make the cut previously for appointment. So they're highly experienced in constitutional matters. I think the problem is that you are trying to kind of plug these holes with acting appointments. And so it creates, I would imagine, the first court that we had, as you rightly point out, Mike, had individuals drawn from academia, and who could be, more brilliant than Acacia Regan and Arthur Chaskelson, etc. So, but that first court, of course, had its own special political and other circumstances. I think that it feels to me as if we're trying to plug holes where the actual underlying issue is that you're not getting the candidates, and why you're not getting the appropriate candidates is because people are not wanting to set themselves up for the spectacle that has happened before. And so, but if we look at the recent process, it's as I've mentioned before, so far calmer, far more rational process, and hopefully that will go some way in getting individuals who are constitutional judges and who practice in that area to actually make themselves available. So I think we are trying to put a band-aid over the deeper problem as to why people, the institutional damage that has happened, and why people don't want to put their names forward. I think just to go back, so while I have no doubt these individuals will do well and bring their knowledge, also there is an acting period, and so institutional knowledge also needs to be passed down, but it also needs to be embedded. And so at some point we need more stability on the highest court. And so I find it disappointing that we have to go this route, good as these individuals are. Just to go back to the point about the Judge Unterhalter matter, I think that for me, it may have a dampening effect on a good candidate putting their names forward, particularly because, Mike, there were 4 vacancies, and the JSC decided only to appoint 2 individuals, essentially saying that somebody as brilliant as Unterhalter is unappointable. And so that, I think, is not going to help the cause of trying to get really good candidates to put their names forward. And so I think one needs to, while it's always invidious to single out an individual, because as you say, this has happened before. And, in our report, we do raise questions about the JSC's then commitment to non-racialism, as per the founding provisions of the Constitution. So one needs to put it in that perspective. So while I think, not to belabor the point, these are good individuals, but they're acting, and we really need a bit more stability on the court. And one can only hope that there will be that in the future, and that those individuals are urged to apply and, in fact, are appointed. And in that way, I think we will, one can then see whether that institutional knowledge has in fact been embedded, and that we have a secure, a stable court for the future. I think that's crucial.
You pointed out that the judiciary is more than just the judges and the courts themselves. It also encompasses the legal profession. We know that lawyers are never the most trusted profession in society, but in this country, it seems that things have reached a bit of a low ebb with the Stalingrad approach, with case after case in which all sorts of delaying tactics and transparently delaying tactics are employed, spurious applications left, right, and center, etc., etc. The courts are speaking out against this. The courts are giving punitive costs orders, but the profession doesn't seem to be saying anything. So we have the law societies, the various bars, the General Council of the Bar and other associations of advocates, and then the Legal Practice Council, the statutory body, which is supposed to oversee the profession. None of them seem to be taking this issue seriously. I think that's a problem.
The only answer here is a resounding yes. It's a huge problem, Mike. And as I said before, it's crucial for the profession to have that body of ethics and to adhere to that, and to know that when you're bringing these spurious lawsuits, that there's going to be some form of penalty. The courts have been hitting back through punitive costs order, and I think that is absolutely correct. I mean, the freedom under law, we had our inaugural lecture in July, and Dario Millo, who's a well-known attorney, he did the lecture, and it was on the so-called SLAP suits, the strategic litigation against public participation, and where people bring spurious lawsuits, mostly powerful individuals, to sort of stop or intimidate journalists and so on. And we've seen that. One of the cases he mentioned was the Zuma and journalist Karen Maughan matter, and that's been in the news lately as well. But the professional bodies have been completely absent. And I think that this is particularly the Legal Practice Council has been, I think, silent and also intimidated by, individuals who perhaps have high public profiles, who are running many of these, making many of these spurious arguments, and I think bringing the profession into disrepute. And emotionally and financially exhausting litigants. And there really is, and I think it's up to us also, civil society organizations, to be doing greater research. In fact, that's what Dario Millo was asking for. What is happening around the world with regard to comparative legislation, with regard to SLAP suits, for example, but also to encourage, to put pressure on, I think, the profession and the Legal Practice Council to, in fact, deal with attorneys who behave in this sort of conduct, who bring the profession into disrepute. So this is a huge area. I think it's undermining of the process of the of sort of fair play and a fair adjudication of disputes. It puts pressure on the judiciary. We've seen abuse of judges by some of these lawyers, and with no consequences whatsoever. The classic Dali and Porphyry Michel Leroux shut-up incident at the Zondo Commission was handled very poorly. And so, no consequence for poor behavior. And so, there's that side of it. And then also the kind of Stalingrad tactics and the SLAP suits. So there's a major area, A, for research, and B, also for civil society, those of us who follow these matters and who follow the judiciary, to be making our voices heard, because accountability is about supply and demand. So if we're demanding that lawyers act better, the judges act better, that the JSC acts better, it's a drip effect to getting that accountability. It takes time, but we need to be saying those things, and we need to be calling it out when it happens.
Yeah, agree. In one of your articles in the Daily Maverick a while back, last year, I think sometime, you quoted Zadie Smith, the author, saying, "Critical thinking without hope is cynicism, but hope without critical thinking is naivete. Critical thinking without hope is cynicism, but hope without critical thinking is naivete." How would you apply that to South Africa today?
And I think for me, it's a call to realism, that we won't be able to solve our problems overnight. South Africa has huge challenges, not least the ones we've spoken about now, but also in other institutions which have all but collapsed. We have to understand that we've had a decade of state capture, which has all but destroyed many institutions. We've seen this rebuilding, but the rebuilding's also been halting because of the political environment that we're in. And so for me, I think often we expect that we are going to have a lot of progress very soon, that, you know, things will magically happen. And I suppose when President Ramaphosa became president, we had high hopes that the rebuild would be faster, it would be better. But of course, we understand that politicians are just that. But for me, what we need to be doing is rethinking what it means to be a citizen. What does it mean to be in this democracy? Why do we prize it above everything else? And particularly, what does it mean to live in a constitutional democracy? And so this moment that we're in, which is one of political and social rupture, it gives us an opportunity, despite a lot of what's going on, to redefine ourselves, to redefine our democracy, to educate the next generation of young people. I think it's crucial to understand, for young people to understand the Constitution, what it means and why it's important. And also to keep talking, because I think it was Cato Regan who said once on a panel she was on, once the noise stops and we stop talking, that's when we should be worried. And to keep building where some people wish to tear down. So it's fine to have hope is a crucial component, and it's not the touchy-feely. It's hope in the sense that people like Rebecca Solnit have written a lot about the political nature of hope. But we have to not suspend our critical thinking. We have to understand how we got here and how we ensure that we get out of this, and how we look to the future. And that's got very little to do with the politicians, even next year's election, important as it is, but it's got to do with us as citizens and as civil society, not to abdicate our responsibility for the rebuilding of our democracy.
As always, our democracy and our country's future is in our hands, first and foremost.
Yeah, it will take a political imagination, Mike. And I suppose in the 90s, you know, we had that. Things were different. The objective conditions were different. But it will take that reimagining. And it's a difficult path. I mean, I talk to a lot of people in civil society, people who are trying to rebuild, trying to reimagine. And it is hard because the conditions now, as I said, are different. And, you know, there's also, we have our socioeconomic indicators seem to be getting worse, not better. We're also in a global environment where there's a recession of democracy, what David Miliband called the pandemic of impunity. And so it takes place against that backdrop. And so we need to reimagine it for ourselves. And that's going to take work. And it's also going to take work from the bottom up. And, you know, from the top is important, but also what's happening at the bottom. But it's often what's happening at the bottom in South Africa that gives one more hope than what's happening at the top.
Let's leave it there. Judith February, the Executive Officer of Freedom Under Law. Thank you very much for sharing some of your time and your thoughts with us, Judith.
Thank you very much. Thanks, Mike.